point. I'm going to hope.
I thought we were taking a break and going to go vote, but if you want me to go first, I'm good.
No, I think we ought to go over there and
Okay.
pray that it comes along and we can return quickly. So why don't we declare this break time for 20 minutes, 4:05, back in the room.
So I'm going to come to you first. And with that, we are in another break. You are watching the second day of confirmation hearings for Judge Ketanji Brown Jackson. I'm Amna Nawaz. The Senate Judiciary Committee is now taking another 20-minute short break. With me here at the table is Marcia Coyle of the National Law Journal. Marcia, you've been watching these last few hours with us now. 2 more hours of questions there for Judge Jackson from Senators Lee, Klobuchar, Cruz, and Coons. I think one of the questions we'd all been asking going into this, when you have the woman who could become the first possible Black woman on the Supreme Court, when are questions about race? When are questions about racism going to come up? And she's been explicitly asked about that in previous confirmation hearings for other roles. But
Right.
you saw that very pointed line of questioning from Senator Cruz there. Tell me about what you noticed about that. What did you take away from that exchange?
Well, first of all, I wasn't surprised because it involved critical race theory, which, as you know, is an academic framework for examining systemic racism. And it's become a really hot topic. It's become part of the culture wars in this country, with many parents involved and believing that their children in the lower levels of their education are being taught critical race theory. But it's always been considered to be a theory that was being examined at the college level or the law school level. Well, Senator Cruz was the one who interjected critical race theory this time, and he did it in an indirect sort of way initially, asking her thoughts about critical race theory and whether it's taught in K through 12 schools. And then he sort of pounced with her membership on the board of a private school, Georgetown Day School, which he said its curriculum was overflowing with critical race theory. And he read off the titles of books and excerpts from the books, and then asked her if she believed in this. And I thought she gave a very thoughtful answer. One, first, she did not believe that any child should be valued less, made to feel they are a victim, or made to believe they are racist. But she also said this was not something that she has reviewed or studied in her position as a judge. And that was why she was before the committee, to be reviewed as a judge. And that sort of shut it down after that. There were other incidents that he raised where she had made references to critical race theory. But I think the attempt to portray her, as an advocate of that really didn't go very far for long. But it was interesting that it came up, and I'm not surprised that it came up because, as I said, it's part of the culture wars now.
This is one of those questions, right? Is can you paint her to be an activist judge? Will you not act as an
Exactly.
so-called activist judge?
Exactly.
If you are confirmed. I know Jeff Bennett has been watching all of this from over at the White House and joins us now. So, Jeff, we heard, of course, critical race theory come up there, references to the 1619 Project. These are all sort of white hot political issues, rallying cries you often hear in conservative circles that have become umbrella terms for a lot of conversations about racism today. But what have you heard from the White House about how they think that Judge Jackson's been handling the questions?
Well, no, the White House and the team that has been assisting Judge Jackson through this confirmation process, I'm told, they anticipated this sort of line of attack. They prepared for it in large part because they're all too aware that this is an election year, and this issue of critical race theory has been something that Republicans had tried to use, and they are using it as a proxy, at least in this setting, for what they view as being a fertile line of attack against Democrats come November. But I think the perspective from those who support Judge Jackson's candidacy is that this idea that she's an activist, or that she's soft on crime, or that she's some sort of 1619 defender or critical race theory acolyte has nothing to do with her record as a judge, but has everything to do with her race, and that Republicans should be held to account for that, and that no white nominee in this setting has ever been asked about how their race informs their views as a judge. So why is she called to account to explain how her race, being African American, might inform her view in that regard? So I think it is something that she has handled rather deftly. The White House press spokesperson earlier today put out a statement and said that President Biden had watched portions of the proceedings, and I'm just looking at my notes here to get specific about what he'd actually said, but that the president was proud of the way that she was showcasing her extraordinary qualifications, her experiences rather, and her even-handedness on them.
Marcia, you and I talked earlier as well about the fact that in this climate, as Jeff just referenced, we're in a midterm election year.
Mhm.
It is very difficult to remove the politics from this process that's meant to be entirely focused on a judicial candidate here.
Absolutely. And this was a very good example. This exchange with Senator Cruz was a very good example of it. And I think, as we just heard, that she was able very deftly to turn this back to why she's before the committee. And that is, she's there as a judge and she needs to be judged on being a judge.
There's also this continued line of questioning about her time on the Sentencing Commission,
Oh, yeah.
specifically about sentences she has handed down to people convicted of child pornography cases. You saw Senator Cruz there bring out visuals, right? There was a
Right, yeah.
ticking down of sort of sentences she's handed out as they related and compared to the government recommendations for those sentences. Do we expect to see more of that line of questioning moving forward?
I think we will. I think that has been Senator Hawley's main issue with her. And he made it very clear in his opening statement that he would be coming back to it as well. So it's a little surprised that Senator Cruz sort of stole his thunder, so to speak. But as they are both potential presidential candidates, maybe there's a little competition going on there. But I have a feeling she's going to have to answer it again. But she's going to probably say the exact same thing she's been saying all along. And earlier this morning, she gave a very thorough explanation for her sentencing in that area to Senator Durbin, who was the first questioner.
And Jeff, I know you've been following this as well, this idea that the politics of this moment, right? All of these culture wars, as Marcia referenced, these are going to come up again and again in the context of a confirmation hearing for a Supreme Court nominee. You noted that outside the hearing room, there's a lot of activity that's been going on in terms of messaging and tweeting from Republicans and others.
That's right. The official Twitter account of the GOP actually earlier today put out a tweet that had the face of Judge Jackson, her initials KBJ, those initials crossed out, replaced with the initials CRT to suggest that Judge Jackson is in some way an avatar for critical race theory. Think back a few weeks ago when she was first offered up as the nominee, there were some Republicans who suggested that her nomination had little more to do with the fact that maybe she might just sort of be some sort of affirmative action pick, setting aside the fact that she is objectively eminently qualified. So you do see this sort of push and pull, the ways in which this confirmation process in many ways has nothing to do with the actual nominee, but has everything to do with what exists right now in the zeitgeist and what Republicans and Democrats have decided to use as a sort of a political battlefield heading into November, and sort of insert into that wood chipper this process, this what should be an elevated process to nominate someone to sit on the Supreme Court for a lifetime appointment. So there sort of is this sort of disconnect between what should be a revered process and the sort of in the mud everyday politicking that happens here in Washington.
All of that, of course, filtering down into the hearing room. And in that hearing room has been our own Lisa Desjardins. She joins us live now from Capitol Hill during this little break in the proceedings. And Lisa, I'm curious to hear from you about this because you've been talking to lawmakers. We saw probably the most aggressive line of questioning, the most pointed line of questioning when it comes to some of these issues that are absolutely white hot in the political conversations right now from Senator Ted Cruz there. I'm curious what you're hearing from both Republicans and Democrats about how they think that hearing is going.
This moment right now, as I think you're getting the sense of, and you're drawing out from Marcia and from Jeff, this is a very critical moment in terms of what the overall tone of this hearing will be like for the next day and a half, and perhaps the taste that is on there in everyone's mouths, and I mean Americans' mouths, as they come away from this hearing. Talking to some Republican sources, in fact, there are some questions in their minds as to whether Senator Cruz is going too far, or is he doing this just right in asserting an issue for many in the Republican base who are concerned about how race is taught in schools. I think most of my Republican sources right now on the Hill and some of them very conservative, are concerned that perhaps this line is going too far, especially because in their impression, Judge Jackson is answering these criticisms directly. So there's a question of when you ask a question, when you make a charge repeatedly, at what point are you harming yourself more than you're harming the person that you might have a critical issue with? So this is a moment where I think Republicans are going to try and figure out, are they going too far or not? Now, on top of this moment is something I continually talk about, is that members of this committee include several who would like to have a higher national profile, specifically several who would like to be U.S. president. Senator Ted Cruz was the second place nominee for the Republicans in 2016. Senator Josh Hawley, who will have his question time approximately 1 hour after we return to the committee room. He's another person who, no secret, would not mind being in the White House. So that is also a factor. It isn't just about what this means for the Republican Party. It's about what it means for these senators personally. And they know to get the Republican nomination, they have to really connect with their base. The question is, are they going too far, and are they hurting to the Republican cause, actually helping the nominee by putting things out there that may not be able to be backed up any further? I've seen tons and tons of responses from Democrats just pushing back at the specific quotations they're using. I could go into that, but I think Judge Jackson did that herself in the hearing. So I think it's an important moment. I sense Democrats are starting to feel that anger in their throats that we've had in the past year, that until this moment in the hearing, I hadn't sensed before. It had been very civil, even sort of joking around between the parties. But I think if this kind of questioning continues after Judge Jackson has already answered these same concerns, there will be a difference in kind of the tension in the room.
But Lisa, we should point out, there's always strategy at play, right? From the senators in that room. We know, of course, Democratic senators are doing what they can. We've seen this even in the morning, trying to give Judge Jackson a break every now and again, right? Either to revisit topics she has already spoken on, or even just saying, okay, you can take a break for a minute, as Senator Whitehouse said, and I'm going to kind of run through some things that I needed to say, just so after 3 or 4 hours of questioning, she doesn't have to talk for a moment. But when it comes to these issues, there's probably no one who can speak better to them than Judge Jackson. So do Democrats have a strategy for how to handle these questions moving forward?
They do, and I think we've seen this play out. I think they're going back and forth. If they feel like she needs more time, they are starting right off the bat and giving that to her, as we saw with Senator Coons. His first question was, what else would you like to say, in response to Senator Cruz? But you notice that he ended his session with her using the other Democratic strategy, which is, I'm going to give your defense for you. I'm going to also bolster what you say by bragging on you in a way that might be difficult for you to do in as many words, to put out a lot of statistics that we believe refute what Republicans are saying. So they're doing it both ways, giving her more time to speak for herself, and then also backing her up in their own words. All of this, though, Amna, it all comes down to the votes, right? In the end, Democrats need 50 votes to get this nominee through. And I spoke to Senator Susan Collins, Republican of Maine. She is one of the Republicans, perhaps the Republicans that Democrats think is most likely to consider voting for Judge Jackson. And we asked her, myself and another reporter, about this idea of her child pornography sentencing, all of these accusations or questions Republicans are raising. Senator Collins said, I don't know of any evidence to believe there's a concern there, and she said she herself, Senator Collins, asked Judge Jackson about her sentencing and whether her sentencing was in line or not. And she is taking Judge Jackson at her word in their personal meeting that her sentencing is in line with all the other judges. And as far as our data shows, that's true. And that's what Susan Collins is looking at. In the end, we can have all these quotes, all of these sound bites from this hearing, but it's votes like Susan Collins that will matter in the end.
And Lisa, before you go, I want to ask you about one more senator specifically, because no one knows this better than you, and you are there in the room. Senator Graham, who has supported Judge Jackson in the past, in her previous confirmation hearing for the DC Court of Appeals, has been among the more animated, shall we say, on the in the hearing proceedings today. And earlier this morning was an incredibly heated exchange between Senator Graham and Chairman Durbin about a number of issues, really, but almost you could call it an airing of grievances from the Republican side. I'm curious what your sources are telling you about Senator Graham in this moment, where he stands, whether what we've seen from him so far is an indication of how he'll go moving forward.
Senator Graham does have friends here in the Senate, but he generally keeps his final decision to himself until the end. He is someone who I've covered him a long time, including when I was a reporter in South Carolina. He is someone who almost prides himself on being willing to make up his mind at the last minute or to go with his gut. And I think that it is impossible to say exactly where he will land on Judge Jackson, except that he also wears his thoughts on his sleeve. He never hides when he's angry, as you say. We know that he is upset about this nomination. He is very openly upset that his nominee of choice, Michelle Childs of South Carolina, was not chosen. He envisioned a beautiful bipartisan world around Michelle Childs. That's not happening. And we know Lindsey Graham is someone who has said in the past, if you do my side wrong, I am going to feel like I can do your side wrong. He said that in the Kavanaugh hearings. So there is a sense that this is a man who says an eye for an eye, and he's unhappy about his nominee not being pushed forward. Now, is he consciously thinking that way? I don't know. Right now, he seems to be indicating he doesn't have a lot of reasons to vote for this nominee, especially in an atmosphere where no other Republican has said that they would. But he does like to be unpredictable. So, and also, Amna, he has voted for every Supreme Court justice that he has had cross his desk in the Senate. This would be his first no. So I'm watching him closely. He's an interesting character to cover. Right now, he does seem to be leaning no, but we'll see.
There is all of that you just mentioned, all of that to keep track of. Lisa Desjardins is doing that for us on Capitol Hill. And Marcia, I know there was a lot covered in the last 2 hours. Of course, I think these issues around critical race theory and so on are probably going to generate a lot more conversation moving forward. But I was particularly struck by an answer that Judge Jackson gave to a Democratic senator about an issue I know you pay a lot of attention to, this shadow docket, right? These are emergency decisions, essentially, that are often unsigned when the judges hand them down, and justices rather. And I'm curious how you think she handled that question, because she is someone who has been very explicit about the need for greater transparency from the bench.
Right.
These are anything but transparent.
Oh, that's true. And I didn't think that the answer was all that forthcoming. And it may be because she has been careful not to criticize the Supreme Court in any way. And I think that had more to do with it than anything. And to really explain, her thoughts on the shadow docket, and if she wanted to say when the court should use it properly, she would have to go into details about the factors that the justices have to consider before agreeing to impose an injunction or a stay as requested by the emergency applicant. And it gets a little bit down in the weeds. And I don't think she was prepared to do that. I think it was more her reluctance to appear to criticize the court, as some have, for its use of the shadow docket.
We also heard her say, right, I'd like to be able, if confirmed, I would like to be able to speak with the other justices
Yes.
to hear their reasons for
Right.
this.
She said the same thing about cameras in the courtroom, that she would like to, if confirmed, speak with the other justices about how they feel before she takes a position.
That's right. Did that surprise you? That issue came up as early as
No.
it did?
No,
No?
it's a perennial question. And I think it was Senator Grassley who brought it up. And it's an issue that he has pursued in his committee as well. And just about all the nominees say the same thing, except David Souter, who said it would happen over his dead body. He's still alive, retired, but alive.
In terms of perennial issues that come before the court, we should note she's obviously asked about a lot of issues that are currently with the court,
Yes.
issues like abortion. And we know that there's a very big case that we could see a decision on later this year, but that would be before Judge Jackson would be seated if confirmed. Is that right?
That's right. It would be. And I was a little surprised that, well, maybe we'll hear more about abortion later today or tomorrow. But and from the Republicans, that's where I would expect it to come from. But they may be feeling somewhat comfortable since all the prognosis is that the Supreme Court is going to overturn its landmark abortion rights rulings, Roe v. Wade and Planned Parenthood versus Casey, in the case they have before them out of Mississippi. So it was just a rather brief exchange with Senator Feinstein, and some thoughts about stare decisis, which is the doctrine of standing by precedents, old decisions, and why that's important. And Judge Jackson did respond in the way you would expect, explaining what stare decisis is and how it contributes to stability of the law for all of us. I was a little surprised it hasn't gotten more traction, but we'll see.
We'll see. Still many hours ahead of
Yes,
us, we
many
should note.
hours.
We are about halfway through the senators on that committee, each having their 30 minutes to ask questions. We're keeping an eye, by the way, on that live picture of the hearing room as people are starting to trickle back in. As soon as the hearings do begin again, of course, we will go there live. I think Jeff Bennett is still with us over at the White House, though. And Jeff, I want to get your take on this because obviously we have heard repeatedly now, I think, from Republicans some central themes. It looks like they're focusing in terms of really trying to challenge Judge Jackson on a few issues when it comes to how she would handle hypotheticals. Would she act as an activist judge? Is she, quote unquote, soft on crime? Are there any lines of questioning folks at the White House have been caught off guard by or surprised haven't come up yet?
No, and the one that they prepared the most for was this notion that Judge Jackson is soft on crime. And in fact, we were told by a White House spokesperson today that President Biden was particularly struck in Judge Jackson's exchange this morning with Senator Leahy, where he basically walked her through her resume. And there was sort of this long recitation of how her work as a public defender was not in any way a detriment, but it was in many ways an asset. And she also talked about how she's from a law enforcement family, and that one of her brothers is a detective, and the other worked his way up through law enforcement, and she knows what it is to have family members out on patrol and not knowing if they're going to come home at night. She also talked about she knows very well the effect that crime has on a community, and the need for law enforcement, as she put it, wasn't some sort of arbitrary concept or a political slogan, that she knows all too well the important role that law enforcement has. And so it was in many ways a way to sort of preemptively neutralize any attack that would come from Republicans. So to answer your question, no, there's been really no line of attack that the White House or the team assisting Judge Jackson feels has landed. And I'll also add that the notion that Republicans, namely Senators Pauley and Cruz, are trying to alternatively paint her as a CRT activist or being soft on crime or somehow being an advocate for child sex offenders. The view from here at the White House is that all of that taken together suggests that Republicans have no serious objection, that all of those different accusations are so laughably unserious. It all speaks to the fact that they can't really pick apart her record and can't pick apart her qualifications. So at least for right now, at almost 4 o'clock Eastern on a Wednesday, the White House and the team, the Sherpa team, feels pretty good about where things are headed next.
Helps to have a clock nearby. We have to remind ourselves, this is where we are right now. This is where we are. Marshall, well, to that point, though, help to put what we've seen in context. There is strategy at play in the room. We've seen Democrats come forward with sort of a strategy of pre-buttal in some cases, knowing what the lines of attack would be from Republicans and trying to get out ahead of them, having Judge Jackson answer questions before those lines of attack are unraveled. Is there anything different about the tone, about the lines of questioning you're seeing in this particular confirmation hearing to previous ones? And I guess Judge Barrett's is sort of another extenuating circumstances, given it was
There's
virtual
several
and
that have had extenuating circumstances. um, I, I I think, as Lisa has told us, at least up until this point, it's been a relatively low temperature hearing, and that is unusual given what we've seen in the last 3, 4 hearings, at least the last 3,
Mhm.
where it was sort of the flip side. You had Democrats complaining about a stolen seat. The Gorsuch seat was stolen from Judge Merrick Garland. Then you had the Brett Kavanaugh hearings, and with the sexual assault attack there. And Democrats complained about Barrett being rushed through. So it's sort of like the mirror image, at least with the Republicans' complaints about the Democratic handling of confirmation hearings. But at the same time as they make those complaints, they're still being extremely courteous to her. And only at one point, when Senator Graham was questioning her about Guantanamo Bay, did it seemed to get really kind of pointed, and it slipped through. But he was more angry, I think, about how Guantanamo Bay is being handled than he was about her handling of the detainee
Right.
representation. And then the cruise was a little that was that was very pointed, I thought. But I think for the most part, Amna, it's been going quite well, and I imagine they're pretty pleased so far.
Well, it's been interesting to see that for all the complaining and previous referencing about how previous nominees were treated, all of them were confirmed
That's
and
right.
are currently Supreme
Yeah.
Court sitting justices. But to the other point about the politics of this moment, about the way that she is being questioned, it's halfway through. We're
Yeah.
halfway through day one. You have to imagine that they have 11 more senators who have 30 minutes each. Then each of the senators have 20 additional minutes tomorrow. We
Yeah,
believe
it's a
that's
lot
how
of
the
time
schedule
to
will go
fill.
out. It is a lot of time, and there's
Mhm.
a lot of room to run. So, what other issues do you expect to come up?
Well, I'm thinking that they are going to get into more of her opinions,
Mhm.
and we'll see
It's over
some of the
500 to go through,
That's
right?
right. But we haven't heard much yet about some of the more political opinions, the cases that she handled against the involving the Trump administration.
Mhm.
And I imagine there are going to be a number of questions about that. But we also don't know anything about her rulings on the environment, labor law, just consumer affairs. There's a lot of stuff that court handles that she's ruled on that we should learn about. And the other thing I was going to say in terms of the low temperature is that you also have to realize that uh, Judge Jackson is going to be one of the dissenters for the most part on this court. There's a
Mhm.
6-3 conservative majority. And so for the Republicans, this isn't like filling the swing vote seat where then it's very intense as to who's going to be confirmed to the court.
Her confirmation would
Right.
not dramatically alter the
No, it
ideological
wouldn't. It's not
balance,
to
right?
say that it's not an important seat that she takes,
Right.
or that she won't be influential in some ways, but in terms of actually altering the direction of the court, it won't.
Jeff Bennett over at the White House, I believe you're still with us too. This does bring up the question of what's at stake here, right? And in terms of the Sherpa, former Senator Jones, who is leading her through this, in terms of all the people who've been advising her and coaching and preparing her, yes, she is clearly qualified. There are some tough questions she's already handled, some tough questions sure to come. Is there a point of concern for the White House? Is there something that they're generally worried about that could potentially derail this nomination?
That has not come up in any of the conversations I've had with White House officials. They seem pretty confident that they'll get the 50 votes that they need, even from senators like Kyrsten Sinema of Arizona and Joe Manchin of West Virginia, who have been obstacles for so much of President Biden's domestic agenda. The two of them have voted for all of President Biden's judicial appointments. In fact, that is the one area of success that this White House has really had, and that's getting people confirmed to the federal bench at a fairly fast clip. In President Biden's first year, he had, I think, 40 or 41 people confirmed to the bench, the vast majority of whom were diverse and or women. And it was intentional. It's also true that given President Biden's experience, we've talked about this, his 50 plus years in public life, his vast experience on the Senate Judiciary Committee. But Ron Klain, who serves as White House Chief of Staff, he was also once a staffer for the Judiciary Committee. So you have sort of layers upon layers of experience here at this White House, people who've had a direct hand in Supreme Court confirmation processes, but who've also been really skilled at and experienced in getting confirmations generally through the Senate to nominate people to the bench. And they've been doing it quickly, quietly, and without controversy. And one of the reasons why President Biden ultimately settled on Judge Jackson was because she'd been through this process 3 times before, for an appeals court position, for the Sentencing Commission that she once sat on. And so this is actually her 4th time in sort of going through this sort of gauntlet. Of course, the Supreme Court confirmation process is. And I'll kick it back to you because I can hear Senator Durbin.
That is the gavel. That's right. She's no stranger to this room. She is back in there now. We're going to go live back now to the hearing.
You are 51% done as of this moment, which feels more like curse than blessing, but I meant it as a good thing.
Thank you.
I think I'm number 12 of 22, so you're just past halfway down on the downhill. Thank you as well for spending time with me in my office, and thank you for answering the questions of the committee today and tomorrow. What you've said in public matches what you've said in private, and that's obviously a testament to your character. That also can be helpful to rebuilding public trust. So thank you for the ways you've engaged thus far. Judge, you are likely to go on to serve a lifetime appointment on the Supreme Court, which means that this is very likely the last job interview you ever have.
And the most public, Senator.
Yeah, these processes are a lot like a proctology exam. That means that it's an opportunity for you to explain to the American people how you view a Supreme Court justice's job and the limits and bounds on that job. So I want to go back to a topic that you and I have discussed a few times, which is how you approach cases. You've told this committee and you've told me in private that you don't have a judicial philosophy yet, but that you think of yourself as having more of a judicial methodology. I'd like to understand that a little bit more. And I think it would be helpful for the American people to understand that argument and that distinction a bit more as well. Earlier today, you said that you, quote, do not believe there is a living constitution. And you also said that you're constrained to interpret the text. And that's, I think you said sometimes that's enough to resolve the issue. So I think I've heard you pay partial tribute to the judicial philosophy of originalism, but you've not adopted it or embraced it as a philosophy or label that applies to you. So maybe one of the places we could tease that out a little bit more is trying to dig into whose jurisprudence you most admire. We've heard many nominees before, like Senator Grassley, former chairman of this committee. I'm not an attorney, so the farming and ranching people where I come from know that John Kennedy is super smart Rhodes lawyer who kind of pretends to be a, aw shucks kind of guy as he picks your pocket. Grassley and
Do I get equal time, Mr. Chairman?
he always gets unequal time. He always gets bonus time. But I think it might be helpful for us to understand who you most identify with, and past nominees before this committee have talked about the mold of particular justices they thought they followed in. And so if you had to tell the American people who you're closest to, who is that justice, or who are those justices?
Well, thank you for the question, Senator. And I must admit that I don't really have a justice that I've molded myself after, or that I would. What I have is a record. I have 570 plus cases in which I have employed the methodology that I described, and that shows people how I analyze cases. I, in every case, am proceeding neutrally, from a neutral posture. In every case, I describe thoroughly all of the arguments that are made in the case to me as a judge, because I want, in my lengthy opinions, for people to understand the inputs. This, I say, is what I'm considering, because I lay out in very, detailed way everything that people have argued in all of the cases. And then when I'm doing my interpretation, I am focused on the text of any statute or constitutional provision. I am looking as appropriate to the intentions of the people who wrote the words, because I view statutory interpretation, constitutional interpretation, those exercises consistent with my limited authority. I am conscious of not interpreting those texts consistent with what I believe the policy should be, or what I think the outcome should be. I am trying in every case that involves that kind of interpretation to assess what it is that the parties who wrote the text intended. And as a result, because my methodology involves these various pieces, and because of the way in which I do things, I'm reluctant to establish or to adopt a particular label, because the idea of how you interpret is just one part of the entirety of a judge's responsibility. As I mentioned, I'm looking at the facts in a case. And my experience as a trial judge helps me to assess the facts from all of the different perspectives of the parties, because I'm able to do that, I think, having heard from parties in all sorts of cases directly as they present their arguments. That's a part of the judging responsibility that isn't really captured by something like originalism or living constitution. And I believe that the Constitution is fixed in its meaning. I believe that it's appropriate to look at the original intent, original public meaning of the words when one is trying to assess, because again, that's a limitation on my authority to import my own policy views. But there are times when the meaning, unreasonable searches and seizures, due process, looking at those words are not enough to tell you what they actually mean. You look at them in the context of history, you look at the structure of the Constitution, you look at the circumstances that you're dealing with in comparison to what those words meant at the time that they were adopted. And you look at precedents that are related to this topic. All of those tools judges use, and I have used, is if you look at my cases.
But when you said that you look at the intent of the
Yes.
authors of a statute, sometimes courts have to say the people who wrote this statute, whether they meant to or not, have done something that we, the judiciary, decides, speaking in the voice of you, is unconstitutional. And deciding that something is unconstitutional requires an interpretive framework for how you get there, right? And so you and I talked in my office about the differences between Justices Kagan, Breyer, and Sotomayor's judicial philosophies. And you told me that you needed time to study that issue further. So assuming that you've had a chance to think about that a bit more, I guess I'd ask you again, what are the differences among the three of their judicial philosophies?
With respect, Senator, I have not actually had time with all of my meetings with senators and the work that I've done to appear before you today. I would say that there are differences, as you see from the various opinions that they have issued. I'm not sure which one I would necessarily follow because it depends on the case. I think their differences indicate that they are looking at different provisions. They are using the various tools that judges use and that I have used in my cases. The idea of striking down a statute as unconstitutional is daunting and should be daunting, I think, for any judge or justice, and would have to be looked at very carefully because of the limited nature of the judicial role and the fact that the policies have been adopted by the branch of government that has that authority under the Constitution.
So I guess I'm surprised after 9 years on the bench that, I mean, you're super smart. Nobody disputes that. And having worked for Justice Breyer and knowing of some of the fights, some of the philosophical arguments he and Justice Kagan had, it just seems surprising that you wouldn't be able to at least not speculate, but reflect a little bit on the nature of those disagreements. Because to say it depends on the particular case, that's fine, but they have different philosophical and hermeneutic approaches to the text. So maybe another way to get at it. I think Justice Breyer, again, for whom you clerked, and Justice Scalia used to travel together and have lively debate circuit conversations. Can you tell the American people a little bit about what Breyer-Scalia roadshow looked like? What were they arguing about?
Well, my understanding is they were arguing, or at least presenting, two different viewpoints as to how the Constitution should be interpreted. And I would say, just as an aside before talking about their positions, that while I have been on the bench for 9+ years, the issue of constitutional interpretation in that sense doesn't come up very often. It comes up to the Supreme Court for sure, but it doesn't come up very often in the lower courts. what Justice Scalia and Justice Breyer, I believe, were debating was the Justice Scalia's notion of originalism, meaning that the words of the Constitution should be interpreted as they were written by the founders in the founding era, and that they should not be considered to essentially to establish principles that modern justices could now apply based on their own view of the needs of society. And that Justice Breyer's position was more toward that latter view, that the idea of the Constitution needing to be interpreted in a way that is consistent with modern sensibilities about the principles that the document reflects. And I would just say that it appears now that the Supreme Court has taken Justice Scalia's view that the prevailing interpretive frame for interpreting the Constitution is now very clearly looking back through history. So we see that even in the Heller case, where the justices, even the justices in dissent, were all analyzing the issues in the Second Amendment through a historical lens, what was meant at the time of the founding. So that is now the way in which constitutional interpretation is done.
But do you identify with that position?
I identify with the position insofar as that's how the text is interpreted of the Constitution. That I am a strong believer, as I said, in precedent, in stare decisis, in predictability, in the rule of law, and the way that the law now interprets the Constitution is through this historical frame.
I'm grateful for your last couple of minutes because I think that it's in the American civic interest for us to understand these different schools. Again, non-lawyer here, but my simple way of summarizing some of what I think I heard you just say is that Scalia argues hard that the Constitution has a fixed meaning and justices aren't really free to depart from it without a constitutional amendment passed by the political branches so that the voters get to hire and fire the people or have a role at the state level in the ratification of a constitutional amendment. And Breyer's position seems to me, and I won't get it precise enough in technical legal terms, jurisprudential terms probably to satisfy him, but that the Constitution is speaking to more abstract principles, and therefore there's a lot more play in the joints of what a justice's job is. And I think the way you summarized their debate was pretty fair. And I also think it's fair for us to want to understand what your position is about it, because you're obviously, as I've said, incredibly smart and incredibly likable and winsome and on the stage for a lot of Americans to look up to. I'm at the rah-rah, hear side of that debate at the level of what is a Supreme Court justice's job. I think that's why a lot of us are still trying to tease out the philosophical distinction, which I think is more than just a methodology, but want to thank you for that answer. You've also brought up the Fourth Amendment a number of times in our conversation, and I would like to talk a little bit more about the Constitution and whether its meaning changes. And so I'd like to go back to the Fourth Amendment topic you brought up in my office. You said, I think, that and correct me if I'm missummarizing your position, you said that originalism wouldn't have much to say about the Fourth Amendment because the Founding Fathers never conceived of a tool, a piece of telecommunications equipment like this. And so I think during our conversation, you said that the original meaning of the Fourth Amendment won't tell you much about what to do with a new technology. My guess is that originalists, and Scalia in particular, would disagree. So what do you do if the text of the Fourth Amendment doesn't answer a question? Where do you go next?
Well, Senator, just to clarify what I intended to say, and I may well have misspoken, there is an originalist take, I think, on the question of what happens with a cell phone. As the Supreme Court held in the Riley case, there was a way in which you assess principles of the Constitution, the text of the Constitution, and apply it to modern technology. And you have to, because there's no question that cell phones didn't exist at the time of the founding. So if the originalist principle is we look only at the Constitution as it relates to things that existed at the time of the founding, there would be no answer to what to do about a cell phone. And so what the Supreme Court has said and done is to determine that the principle of the Fourth Amendment with respect to searches is to determine whether there is a reasonable expectation of privacy. They also have looked at property interests with respect to whether or not there's an invasion of privacy, and then determined from history what that reasonable expectation of privacy related to back at the time of the founding, and analogized to current circumstances related to things like cell phones. It's a method of interpretation that allows you to, instead of the alternative, which would be don't worry about the history, just look at the words in the Constitution and say, what do I think is reasonable or unreasonable with respect to police officers searching cell phones? That's not the way the Supreme Court handles it. They try to determine what was unreasonable historically, and then given those principles, historically it would be unreasonable for police officers to enter someone's home, to rifle through their papers and documents. They then analogize to current circumstances and the fact that a cell phone is like your personal file cabinet. And they say, okay, given what we understood the framers to have intended about the need for a warrant or the need for protection against unreasonable searches, we're going to apply that to modern circumstances. It's still an originalist way of analyzing the current dispute.
So are there non-originalist ways to wrestle through that same question? And what would they be?
One could imagine that rather than referencing history at all, that the court would look at the Constitution. It says no unreasonable searches and seizures, and would just ask in light of modern sensibilities, in light of what we would think would be reasonable today, or what the court itself would think would be reasonable today, we'd apply that modern understanding to the cell phone situation. And the danger, I think Justice Scalia would say, is that that's a kind of framing that permits judges to make a determination based on their own views rather than hewing themselves, as Senator Lee said before, that Justice Barrett pointed out, hewing themselves to the text of the Constitution.
And does Breyer have a different view?
I haven't, I'm just trying to think. My understanding of the living constitutional principle is that it's closer to looking at the needs of modern society. But I'm not well versed in it, in part because the Supreme Court has now so clearly taken the historical perspective, the originalist perspective in its interpretations.
You brought up the cell phone example with me, but I know you have others. What are some other areas of life where the original meaning seems to be 2.5 centuries removed? What are places that the Constitution seems to not speak to?
Well, Senator, I'm reluctant to spell out different circumstances. What I will say is that when you look at the language in the Constitution, there are some provisions that are completely clear on their face without any question of what was intended. The age of the required age of senators, the required age of the minimum age of the president. These kinds of provisions, all you need is the text, and there you are. But there are provisions of the Constitution that are broader than that, and therefore some interpretive frame is necessary. And to the extent, I mean, every question the Supreme Court gets that involves new technology, for example, that relates to constitutional provisions will require some kind of analogy, I think. But I can't speak to anything more than that.
You have described Justice Breyer's constitutional approach as pragmatic. What does that mean?
I understand it to be, and his approach to be about ensuring that the rules that follow from the Supreme Court's determinations are ones that make sense and are workable.
He said recently, explaining his approach to interpreting a statute, you're not going to go outside the words, but it often doesn't give you the answer. And you look at the history and you look at its purposes and you'll look at the consequences too, and you'll try to evaluate them from that, the point of view of what a reasonable legislature writing this statute have thought that these words were there to achieve. Do you align yourself with that position?
In the broad sense that what it is that the court is tasked with when statutory interpretation is being undertaken is to achieve the purposes of the legislature. The text is the primary, and in most cases, sole indication of what the legislature intended, as opposed to the court saying, I see this statute, but I'm, uncomfortable with how it's going to turn out or what it's going to mean. And so I'm going to import my own policy perspective. Instead, the court is constrained to say, regardless of what I think the right policy objective should be in this, with respect to this law, my purpose, my requirement is to determine what Congress intended.
But with respect to legislative intent, when a Congress of 535 often distracted people, 100 in this body and 435 in the other, pass something, by a 2-to-1-ish vote, and it's a part of a large piece of legislation, how do you determine what the intent is when it's 535 people doing something that has many, many different purposes for why somebody might vote yes?
Well, you look at the text. I mean, the way in which statutes are interpreted is based on what the legislature says. There are times in which there are statutes in which Congress includes a purpose statement, for example, in the actual text of the statute. You look at the text of the provision. If that isn't clear, you look at the structure of the statute. There are canons of interpretation that courts use to evaluate and interpret statutes. Things like a word that appears in the section that you are interpreting should be defined the same way it is in another section. The same word being used, Congress probably intended for it to have the same meaning. So there are tools in the law that exist to help courts to interpret the text. But again, the goal is to interpret the text as a means of understanding and reflecting what Congress intended. And of course, in statutory interpretation, if Congress decides that the court has gotten it wrong, then, as has happened many times, Congress comes back and clarifies and tells the court, no, this is what the statute means.
I want to go back to an exchange you had with Senator Cornyn. Substantive due process is a doctrine that often allows courts to create new fundamental rights. What's the test for determining a new fundamental right?
The Supreme Court has said in the Glucksberg case that the fundamental rights that are recognized or that are included in substantive due process are those that are deeply rooted in the nation's history and tradition. In a case prior to that, the court had defined it as the rights that are implicit in the ordered concept of liberty or the concept of ordered liberty. So there are standards for the courts to use to identify these types of rights.
So did the Supreme Court use this test in Roe or Casey?
In Roe and Casey, I don't know that the court used that formulation. I know that after Casey, the court has determined not so much that the right to terminate a woman's pregnancy is fundamental. The right exists and it's subject to the framework in Casey that allows for regulation so long as there's not an undue burden on the exercise of the right pre-viability.
I think some of what we're wrestling with here is the question of, and I think what Senator Cornyn was driving at, is how particular the concept of deeply rooted goes and how that really is a bound on what the judiciary can do. But I want to thank you. We're nearly at time. I want to thank you for engaging in the back and forth. I want to think more about what you've said and look forward to further discussion tomorrow. It still appears to me that there's a very basic difference between a judicial philosophy and a judicial methodology and how you go about applying that when you're interpreting a law and making a determination about constitutionality or not. And I know that you haven't claimed a judicial philosophy at all, but a judicial philosophy of originalism here. But I do think the fact that you've at least nodded to it in the committee hearing today is in and of itself a pretty great testimony to how much of Scalia and Bork's work has moved the legal field. So I'm grateful for the time you're taking with us. I'll look forward to listening tonight and talking with you again tomorrow.
Thank you.
Thank you, Senator Sass. Senator Blumenthal.
Thanks, Mr. Chairman. Thank you, Judge, for your patience and your perseverance. I want to begin just by thanking you also for an extraordinary moment in our history. I think we all as Americans feel excitement and pride in really making history here. And the old saying, a picture's worth 1,000 words, as I look at your parents and your husband and your daughters, what I see is America and the best of America. So I think we should all feel that excitement and pride in this moment and the extraordinary journey that has brought you here. You will make the court look more like America, but also think more like America in the obstacles and challenges that you've overcome to be here. We don't know all of them, but you will provide a very important perspective, indeed a unique perspective that the court needs more than ever at this moment in its history. There are a lot of people who are book smart. There are not as many people who are person smart, and you are both. That kind of emotional intelligence is what our courts need, not just our Supreme Court. So I want to really begin by asking you, as a role model for others, to talk a little bit to the young women and girls of America, particularly Black young women and girls, about those challenges and obstacles that you've had to overcome to be here and what's helped you do it.
Thank you, Senator. I am humbled and honored to have the opportunity to serve in this capacity and to be the first and only Black woman to serve on the United States Supreme Court. I stand on the shoulders of generations past who never had anything close to this opportunity, who were the first and the only in a lot of different fields. My parents, as I said, were the first in their families to have the chance to go to college. I've been the first and the only in certain aspects of my life. So I would say that I agree with you that this is a moment that all Americans should be proud.
Now, you've never been a prosecutor. A lot of us on this panel have been prosecutors. I was the U.S. attorney, the chief federal prosecutor in Connecticut for 4.5 years, and then I was attorney general of my state for 20 years. But I would say one of the most meaningful cases in my career was as a defense counsel. I was asked by the NAACP Legal Defense Fund to represent a Black man on death row in your home state of Florida. He had been convicted of murder and rape, had been on death row for a number of years. And I took the case because I was asked to do it, and eventually, somewhat to my surprise, found, in fact, he had never done the crime of which he had been convicted. And eventually, we won his freedom because the prosecutor in the case concealed evidence, which was a violation of his constitutional rights. And he was a free man as a result. Your husband, as a surgeon, saves lives. Lawyers don't do it often. But I know from personal experience the importance of having a good representative, an advocate, a counsel, because in that case, he had been denied it when he originally went to trial. And only after years in both state and federal courts was the truth vindicated. So I want you to talk a little bit about why it is important for defendants to be represented by zealous, really aggressive and energetic advocates who tell the truth to the court, put on the evidence, and present the best possible case for a defendant accused of a crime.
Thank you, Senator. The idea is one that is rooted in our Constitution. The framers were concerned about government overreach in a lot of different areas. The provisions of our Constitution are protecting individual liberty from government overreach. This is why we have provisions about limited government. And there are many provisions in the Constitution that are limiting government action when it comes to the deprivation of liberty, because the framers understood how important liberty is to our society. And so there's the Fourth Amendment, there's the Fifth Amendment, there's the Sixth Amendment, there's the Eighth Amendment. These provisions are crucial, and it is zealous defense counsel that ensures that the government is protecting these rights, that ensures that these rights are protected and that people are getting due process in the criminal justice system. And that's to all of our benefit. That helps everyone in America when we ensure that liberty cannot be denied without due process. It's defense counsel, as I said, who are making arguments, and they're not condoning the criminal behavior. They're making arguments on behalf of clients in defense of the Constitution and these constitutional values. And as a judge, I now see how important it is for me to be able to make my decisions after hearing from both sides. That's crucial. We have an adversarial system, which means that judges are presented with arguments from both the prosecution and the defense. And only when I'm able to hear from both sides can I make a just, fair determination. And fairness is the hallmark of our constitutional scheme, and it's what makes us the best criminal justice system in the world.
And it's not only the reality of fairness, but also the perception of fairness, the public's understanding of how courts work that is essential to the credibility that courts have, correct?
That is correct.
And so I feel very strongly, I know that a number of us on the committee agree that more transparency, more visibility is important for the public to understand what goes on in the courtroom. I know you feel transparency is a good thing. You've been asked about cameras in the courtroom. I'm a supporter of Senator Grassley's Sunshine in the Courtroom Act, as well as Senator Durbin's Cameras in the Courtroom Act. I am hopeful that the court, the United States Supreme Court, actually will back these proposals because their support would be very important. Tell me how you feel about the basic principle of transparency and more visibility.
Well, Senator, one of the reasons, as I said, that I write such long opinions is because I want everybody to know exactly the arguments I've considered, the facts that I've reviewed, and in pretty fine detail, the course of my reasoning. And I've done this in 570 opinions. I think it's important for public confidence, as you say, for people who are bound by the law and who are affected by the courts to know what the court's views are. With respect to the issue of cameras in the courtroom, I understand that that is something that is proceeding through Congress. And if I was confirmed, I would look forward to talking with my colleagues to understand the positions that people have regarding that issue.
I appreciate that response. One of the other areas that I think is important to transparency and to public trust and confidence in the court is visibility as to its own decisions, which I think is directly contradicted by the shadow docket. You've been asked about it before, but I just want folks to understand that some of the most important decisions of the Supreme Court have been decided, or at least issues resolved, without oral argument, without briefs, without any public explanation. A controversial travel ban has gone into effect. The first federal execution in 17 years was permitted. Statewide COVID restrictions were enabled. The collection of data in the 2020 United States Census and enforcement of voting restrictions in the 2020 presidential elections, as well as decisions relating to immigration and blocking the Biden administration from enforcing a federal moratorium on evictions imposed because of the COVID-19 epidemic. Americans have a right to an open, full, fair proceeding with a record of the court's reasons for making decisions. So I hope that you will urge your colleagues when you talk to them about cameras in the courtroom also to do less on the shadow docket. And I hope that perhaps if they don't, Congress will take some action. I finally want to ask, so far as this issue of transparency is concerned, about codes of ethics. you have followed a code of ethics as a district court judge and court of appeals judge, correct?
I have.
Does that code of ethics apply to the United States Supreme Court?
My understanding is that it does not.
Correct. My hope is that you will perhaps urge your colleagues as well to support a code of ethics. They haven't done so as yet, but I think we have an obligation in the Congress to set forth a code of ethics, and I hope they'll support it. Senator Durbin and others of us have supported that kind of measure as well. And I would just ask you whether you'll raise it with your colleagues if you're confirmed.
Senator, certainly if Congress is taking anything up that requires our review, I would absolutely consider it. And even if not, I would consider it,
Thank you.
talking to them about it.
Thank you. You know, the reason I raise these points is that I respect the United States Supreme Court. I've argued 4 cases before it. I was a law clerk to Justice Blackmun, who, by the way, was from Minnesota, Mr. Chairman. In fact, he was known as one of the Minnesota Twins when he was appointed because he was thought to be exactly like then Chief Justice Warren Burger, who also was from Minnesota in his very, very conservative views. And as it happened, Justice Blackmun became one of the most progressive members of the court over the years that he served. He had a capacity for growth and for learning and listening, which I believe you have, and I think it is one of the most important characteristics of anybody who serves on the court. But I do think the court's crisis of legitimacy is the result of divisions within the court, the polarization and politicization that has drawn lines, the process that has happened in recent years in confirmation proceedings. And so I really think that consensus building bridges with your colleagues will be immensely important. I think that's one of the reasons that the president chose you, having talked to him about it, that you have that kind of persuasive and forceful intellect, but also the personal charm and warmth and depth that will enable you to do it. Maybe you can tell this committee about how you worked on the Sentencing Commission, for example, or in your previous experiences on that kind of consensus building.
Thank you, Senator. Consensus building was one of the things that Justice Breyer was particularly good at in terms of his personality. In the time that I clerked for him, I witnessed the way in which he continually reaches out to colleagues, continually seeks common ground. And it's something that I would hope to be able to emulate if I were to be confirmed. When I worked on the Sentencing Commission, the commission is a 7-member body working on sentencing policy, which is at times a pretty contentious effort because we're talking about criminal justice. As commissioners, we are working on policy issues related to appropriate sentencings, and by statute, the commission is a bipartisan group. And during my 4 years as a commissioner, I was able to work well with other members of the commission to find common ground, to work on issues, to come together. And the vast majority, I heard a statistic that something like 95 or 97% of the votes that the commission took were unanimous. And that happened because of a lot of effort and an intention on the part of all involved to see if we could work together. And that would be the kind of thing that I would hope to do if I was confirmed to the Supreme Court.
You've mentioned in your previous testimony the challenges of applying the law to evolving and new technology. Obviously, the internet raises exactly those questions. Congress passed the Electronic Communications Privacy Act in 1986 when the internet was barely recognizable. It was nascent, just starting. And now our nation faces a mental health crisis. It is partly aggravated by the pandemic, the isolation and anxiety that's resulted from it, but also by the internet and by the tech platforms that drive toxic content at children as a result of these black box algorithms that nobody really understands. Literally, no one understands because the tech platforms want to keep them secret. And we are trying to upgrade the law and update it to give parents tools to have greater visibility as to what their children are doing and to give parents and children tools to protect them against some of the bullying and eating disorder content and even suicidal and substance abuse stuff that they are driven to see. And Senator Blackburn and I have introduced a bipartisan measure, the Kids Online Safety Act, that will provide a more modern solution to a modern problem, to update the law to account for the role of social media in our ongoing and aggravating mental health crisis in this country. Do you agree that it helps the Supreme Court and judges in general to do their job when Congress updates our statutes to account for technological change?
Thank you, Senator. The role of the court is to interpret statutes when there are disputes related to the statutes, and in circumstances in which statutes have not been updated, I don't think it's surprising to note that there are disputes about the meaning of the statute, about how it applies. And so to the extent that Congress undertakes to make amendments and make the changes, I think it helps courts. Maybe there'll be fewer disputes or easier disputes to resolve.
Easier disputes to resolve in the sense that, and I've seen it happen, a judge will say, I don't know what Congress meant to do in this kind of situation because this law was written at a time when none of this stuff now existed. I'm sure you faced that situation. I think it's true of social media and the dangers to children as a result of the toxic content that they often find and often seemingly are addicted to use again and again and again because it's part of the business model of those social media and big tech platforms.
Yes, I have faced this situation. One of my cases, the Alliance of Artists and Recording Companies versus General Motors, is a case that I ended up writing a couple of opinions about. It involved a statute of Congress related to digital recording audio devices and whether or not royalties were required for the purchase of those kinds of devices. And it was enacted at a time in which recording technology was at a different stage than it is now. And disputes arose that came before me regarding whether or not to apply the royalty requirement in that statute to modern recording devices, and in particular, the recording devices that are now in automobiles. When you take your CD and you put it in your own car and record onto the hard drive of your car, is that the same thing as putting your CD in one of those machines that records from CD to CD? And you give the second recording to all of your friends? That was that was what the statute was originally meant to cover. And the question was whether recording to your own car's hard drive counted. And it was a very interesting interpretive exercise. But again, it was the kind of thing in which I was focused on trying to ascertain what, based on the text of the statute and the definitions in the statute, what Congress intended this statute to cover.
And cars, other devices, appliances at home collect huge amounts of data, don't they? And as consumers, we feel we own that data. It's ours. But it can be bought and sold, exchanged and mined in a way that right now consumers have no consent over. And it enhances the dominance of just a few of those tech companies, just a few of the corporations. Corporate power is emboldened and enabled in many respects by the amount of data they collect. It's also enabled by forced arbitration. We've had a reference to it already today with respect to complaints about sexual harassment, which fortunately we have addressed. I've been proud to work on the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which President Biden signed after we passed it just a few weeks ago. I've heard harrowing stories from survivors of sexual assault and victims of workplace harassment who were silenced and denied justice by forced arbitration. But forced arbitration applies as well to everybody who has a cell phone. You have a forced arbitration agreement. Many workers have forced arbitration agreements. Nursing homes have forced arbitration agreements. The point is that you have dedicated your life to access to the courts, the right of a trial, the right to a jury, the right to a judge. None of it is possible where there is a forced arbitration agreement. That's why I've worked on a measure called the FAIR Act that would make any forced pre-dispute arbitration agreement invalid and unenforceable. If both sides want arbitration, that's fine, but access to the courts should be available to everyone. I know that you're limited as to what you can say about measures that are before us and policy issues, but I hope that you will consider the trend that the court has adopted in support of forced arbitration and denial of rights like class action, and review whether they are appropriate. Let me just finish with a couple of quick points. First of all, on the Harvard Law Review article on registration of sex offenders, convicted sex offenders. I must say, I read this article several times. In my view, it is analysis, not advocacy. Would you agree?
Absolutely, Senator. As a law school student, I was trying to do what law school students do, which is analyze a new set of legal provisions. These laws were new, and I was trying to assess what criteria courts could use to look at them. I was not making an argument about them at all.
Exactly. And by the way, one of those statutes was in Connecticut. It was challenged on constitutional grounds, double jeopardy. It went to the United States Supreme Court. I defended it there. It was upheld 9-0. I don't know whether your article was cited, but I would put this law review article very much in the category of analysis, the distinction between prevention and punishment. I would call it protection not punishment or prevention. That's the argument that I made to the Supreme Court. I ask that this article be put in the record, Mr. Chairman.
Without objection.
By the way, it took me 2 or 3 times to get through it, so no disrespect to you or the Harvard Law Review. The issue of child pornography, you mentioned, I think, that in your decisions on these sentencing cases involving child sexual abuse material, which, by the way, I agree is absolutely horrific, abhorrent. It's the reason that Senator Graham and I have actually sponsored a measure called the Earn It Act that addresses it. But you said that you imposed a sentence that matched the recommendation by either the prosecution or the probation office in most of the cases where you did that sentencing. Is that right? Do I have that in mind?
Yes, senators. In looking back at the records concerning my cases, it looks as though I had 14 cases that involved either child pornography, internet, interstate travel to meet up with a child for sex, the sex crimes related to children. And in 10 of those 14 cases, I imposed a sentence that was consistent with or greater than what either the government or the prosecution requested.
The probation office.
Excuse me, sorry, the government or the probation office.
And let me just ask you, the probation office is an independent arm of the court that investigates the defendant, looks at the crime, the defendant's background, his family situation, all of the relevant factors involved in sentencing, including the sentencing guidelines, and then independently and impartially makes a recommendation, presumably to serve the interests of justice in that particular case based on the individual facts there. Is that roughly a correct description?
That is correct, Senator. The probation office works within the court system. They are independent of the parties and they investigate and make recommendations in cases concerning what the probation office thinks is an appropriate sentence.
Thank you. Let me just finish by saying much of America is watching these proceedings on a split screen. On one hand, they are literally seeing the death and destruction in Ukraine, Russia's brutal, barbaric assault on individual rights, basic freedoms that we often take for granted here. And we are exercising those rights right here. You are a teaching lesson. This proceeding is a teaching lesson about the importance of democracy. The people of Ukraine are fighting for it. They are dying in their neighborhoods and streets and their homes. They are huddled in basements. Their men and women are resisting valiantly and bravely against a huge military force that Russia has unleashed and a reign of terror from the skies simply because they believe in the ideals of freedom and law that we are seeking to preserve here. And so on this side of that split screen, I think it's important that we do our best to honor the norms and the rules that you've sought to uphold throughout your life. And I'm proud and excited to be here with you and your family as we go through this process. And I look forward, as I hope many of us do, to a bipartisan majority in support of your candidacy. Thank you. Thanks, Mr. Chairman.
Thank you.
Thank you, Senator Blumenthal. I'd like to bring everyone up to date. We have several considerations. The remaining senators for questions the endurance of our witness, Judge Jackson, votes on the floor, request for compassionate release by a number of people in the audience. Here is where we stand. We're going to have Senator Hawley followed by Senator Hirono. Then we're going to take a 20-minute break because that's when we think there'll be some votes on the floor. We can take care of those and get back in 20 minutes. Then we will return from that break to Senators Cotton and Booker. Then we'll take a 30-minute break or so for dinner. Then it'll be Senator Kennedy, Padilla, and Tillis. And we're going to start off tomorrow with our two Senators Ossoff and Blackburn. So we should finish in the 9 to 10 o'clock hour this evening, God willing. So at this point, I recognize Senator Hawley.
Thank you, Mr. Chairman. Judge, nice to see you again. Thank you again for being here. Congratulations again on your nomination. I want to start where Senator Blumenthal left off. I want to talk with you about some of these cases. I mentioned them yesterday, so I know you know which ones I want to talk about. These 7 cases, child pornography cases, in which you had discretion. They came before you. You had discretion to sentence one way or another in these 7 cases. Not every case, of course, do you have discretion. Sometimes the law requires you to impose a sentence, certain sentence. But in these 7, you had discretion, and in each of these 7, you chose to depart both from the federal guidelines and also from the government's, the prosecutor's recommendations. Senator Lee's asked you a little bit about this. Senator Cruz has asked you about it. He had a chart with the 7 cases on it. Before we jump into those, I just want to correct the record on 1 or 2 things. Senator Coons suggested that in 3 cases, Nickerson, Wynn, and Fife, you actually imposed sentences either within the guidelines or at the same level of the prosecution. But in Nickerson, you didn't have any discretion. That was an 11C1C case. The law bound you. And Wynn wasn't a child porn case, and neither was Fife. Just one other quick thing to clarify. As to this comments about the probation office doesn't issue national guidelines, right? I mean, the probation office doesn't issue sentencing guidelines. They're not public. They're not recommended to all judges. The probation office provides advice to judges case by case, usually in private, usually not available to the public. Is that right, Judge?
Not exactly, Senator. The probation office in criminal cases is assigned by the court to work with respect to the evaluation of cases, in every case consistent with Congress's requirements. The probation office prepares a pre-sentence report in which they review all of the statutory factors concerning sentencing. Congress has a statute for sentencing. It requires judges to consider the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote various purposes of punishment. There are many purposes listed in the statute, and the probation office is the arm of the court that does factual investigations in every criminal case, unless there are certain cases in which you can waive it, but the background is the probation office's assessment of the facts related to a particular sentence and a particular crime. And the probation office's report, when a court sentences, actually, in most cases, becomes the findings of fact of the court. And so the probation office appears just like the prosecution and the defense. The probation office has written a report and they make a recommendation to the court based on their independent analysis related to the facts of a particular crime and defendant and sentence.
Understood. So they give the court counsel, understood. However, they don't issue guidelines. They're not uniform. It is by its very nature a case-by-case inquiry, as you said. The report goes to the judge. As I understand it, the pre-sentencing report, I'm sorry, the probation reports are not public in all of the cases that we're talking about here. I'd love to see them if they are. But it's not as if there's one set of guidelines that are federal sentencing guidelines and then there's the probation guidelines. The probation office is giving advice to the judge. It varies case by case. but
Senator,
it's not the same.
sorry, I thought you were done.
No, that's all right. Let me ask you about a specific case. I mean, let's talk about, I listed these 7 cases in which you had discretion and you did not follow the prosecutor's recommendation or the sentencing guidelines, but let's just talk about one of them because we've talked about some of them as a group. Let's talk about United States versus Hawkins. I think that's one you probably remember from 2013. The defendant there was Wesley Hawkins. He was 18 years old at the time. He uploaded 5 video files of child pornography from his computer to YouTube. This is how the police got onto him. He then uploaded another 36 depictions of child porn and other lewd photos of children to his iCloud account. When the police executed a search on his apartment on the premises, they found 17 videos on his laptop and 16 images of child pornography, all of them very graphic, some of them involving very young children. 17 videos in particular. This is from the government sentencing memorandum in this case. Just so we understand the facts, here are some of the videos that the government charged and they recovered. There was a 24-minute, 6-second video depicting a 12-year-old male committing a sexual act. I'm not gonna read exactly what it was. There was a 1-minute and 57-second video depicting an 8-year-old committing a sexual act. There was an 11-minute and 47-second video depicting an 11-year-old committing a sexual act and being raped by an adult male. There was a 15-minute and 19-second video depicting 2 11-year-olds committing sexual acts. There was a 7-minute and 51-second video depicting a 12-year-old committing a sexual act. So, as the government said in this case, and I'm quoting now from the transcript of the sentencing hearing, 17 videos is a lot. And some of the videos, including the ones that are described in the statement of the offense, and I've just related some of them, are very lengthy and include numerous images, numerous views, sometimes collages, sometimes multiple victims. You see the act in progress. The government goes on to describe some of these as sadomasochistic images. So this is a tough case. This is one of those tough cases you were referencing earlier. You talked about it this morning. Said these cases are terrible. This is one of them. This is terrible stuff. This is not a good guy who's doing this stuff. Guidelines recommendation in the case was 97 to 121 months. So if I'm doing my math right, that's up to 10 years. And in this case, the guidelines recommendation was essentially written by Congress because in the PROTECT Act of 2003, Congress specified what they wanted the range to be in these kind of cases. And Congress also specified what they wanted the mandatory minimums to be. I know you remember the PROTECT Act because you've talked about it. You've given lectures on it. And it was enacted, as I said, in 2003. It was 84-0 was the vote here in the Senate. The reason the PROTECT Act was put into place is the Senate was concerned over lenient sentences by judges in child porn cases, which is what you described. You said about it, there was an increasing perception on Capitol Hill and within DOJ that liberal judges were to blame for the downward pressure on federal sentences and that legislation was necessary to rein them in. That's you in 2011 describing this law. So Congress has set the guidelines here, 84-0 in the Senate. I noticed the chairman voted for it, as did a number of other members of this committee. So the Congress sets the range. Essentially, it's 97 months up to 10 years. Now, the prosecutor in this case, this is in D.C., of course, you're on the federal district court. Prosecutor in this case, it's a liberal administration, I think it's fair to say. This isn't the state of Texas. See my colleague from Texas next to me here. Prosecutor in this case, nevertheless, still asked for 2 full years in prison. You gave the defendant 3 months. Guidelines called for 10 years. Prosecutor wanted at least 2. You gave him 3 months. And when you did, you made a number of arguments and statements in the record. And I'd like to go through some of them because I've read them all. And the first argument you made was that the federal guidelines that punished child porn offenders, the ones that Congress wrote, were, and I'm quoting you now, are in many ways outdated. That's your quote. And you went on to say about why you thought they were outdated. I'm going to quote you again. You say, and I quote, "I don't feel that it's appropriate to increase the penalty on the basis of the number of images or prepubescent victims," meaning little kids, "as the guidelines require, because these circumstances exist in many cases, if not most, and don't signal an especially heinous or egregious child pornography offense," end quote. I just want to ask you about that because I just have to tell you I'm having a hard time wrapping my head around it. We're talking about 8-year-olds and 9-year-olds and 11-year-olds and 12-year-olds. He's got images of these. The government said added up to over 600 images, gobs of video footage of these children. But you say this does not signal a heinous or egregious child pornography offense. Help me understand that. What word would you use if it's not heinous or egregious? How would you describe it?
Thank you, Senator, for letting me address the concern that you've put forward based on the record that you've reviewed. As a judge who is a mom and has been tasked with the responsibility of actually reviewing the evidence that you would not describe in polite company, the evidence that you are pointing to, discussing, addressing in this context is evidence that I have seen in my role as a judge. And it is heinous, it is egregious. What a judge has to do is determine how to sentence defendants proportionately consistent with the elements that the statutes include, with the requirements that Congress has set forward. Unwarranted sentencing disparities is something that the Sentencing Commission has been focused on for a long time in regard to child pornography offenses. All of the offenses are horrible. All of the offenses are egregious. But the guidelines, as you pointed out, are being departed from even with respect to the government's recommendation. The government, in this case and in others, has asked for a sentence that is substantially less than the guideline penalty. And so what I was discussing was that phenomenon, that the guidelines in this area are not doing the work of differentiating defendants, as the government itself indicated in this very case. And so that's what I was talking about. But I want to assure you, Senator, that I take these cases very seriously, that these cases include the notion by many defendants that the folks at issue, the defendants themselves, are collecting these images on the internet. They're terrible things that have happened, but they're not involved, say the defendants. They're not focused on, what is actually happening to the children. And so part of my sentencings was about redirecting the defendant's attention. It's not just about how much time a person spends in prison. It's about understanding the harm of this behavior. It's about all of the other kinds of restraints that sex offenders are ordered rightly to live under at the end of the day. The sentences in these cases include not only prison time, but restraints on computer use, sometimes for decades. Restraints on ability to go near children, sometimes for decades. All of these things judges consider in order to affect what Congress has required, which is a sentence that is sufficient but not greater than necessary to promote the purposes of punishment.
Yeah, well, let me just ask you about that last point, because you've said this a couple of times now, the sentences that Congress require. Congress wanted the guidelines to be mandatory. Congress wrote the guidelines in this case. They wanted them to be mandatory. They gave the courts factors to consider to choose between the sentencing range. Congress wanted you to choose between 97 and 121 months. That's what Congress wanted. The Supreme Court in Booker said that the sentencing guidelines would be discretionary. So the Supreme Court gave you the discretion. But if we're talking about what Congress has wanted, Congress wanted them to be mandatory. My only point in raising that is just to say that you had discretion in these cases and you used your discretion to choose the sentences that you did. Let me ask you about some of the things, though, that you said, because you said this morning, and I appreciated it, how you want to direct the defendants. You want to get them to own up to what they've done in these cases. And I thought that was powerful, and I thought it was right. But let me just ask you about what you said to this defendant. You said to this defendant, for whom you sentenced to only 3 months in prison, that your collection, I'm quoting you, your collection at the time that you were caught was not actually as large as it seems. The government felt the need to respond to you on the record. They said the government doesn't believe that it's appropriate to just disregard the number of images, that the number of images can be appropriate. And indeed, in this case, the defendant has amassed an extremely large collection of child pornography. But you disregarded that. You also told the defendant, you said this seems to be a case where you were fascinated by sexual images involving what were essentially your peers. And then you went on to say the defendant was merely trying to satisfy his curiosity. Curiosity is your word. One more thing on this, same idea. You said you were viewing, this is you to the defendant, you were viewing sex acts between children who were not much younger than you. And this whole discussion is about why you're only giving him 3 months. Judge, he was 18. These kids are 8. I don't see in what sense they're peers. I've got a 9-year-old, a 7-year-old, and a 16-month-old at home. And I live in fear that they will be exposed to, let alone exploited, in this kind of material. I don't understand you saying to him that they're peers and that therefore you were viewing sex acts between children who are not much younger than you, and that's somehow a reason to only give him 3 months. Help me understand this.
Senator, I don't have the record of that entire case in front of me. What I recall with respect to that case is that unlike the many other child pornography offenders that I had seen as a judge and that I was aware of in my work on the Sentencing Commission, this particular defendant had just graduated from high school. And some of, perhaps not all when you were looking at the records, but some of the materials that he was looking at were older teenagers, were older victims. And the point, Senator, is that you said before the probation office is making recommendations and they do so on a case-by-case basis. That is what Congress requires. That this is not done at the level of
But you had discretion, Judge. You admit that, right? I just want to be clear.
Senator, sentencing is a discretionary act of a judge, but it's not a numbers game. It's not, I understand that Congress wanted the guidelines to be mandatory. The Supreme Court in 2005 determined that they couldn't be, in an opinion by Justice Scalia, determined that they couldn't be, and Congress since then has not come back to amend them or to change them or to make them mandatory again. And so there is discretion at sentencing. And when you look at the sentencing statutes, Congress has given the judges not only the discretion to make the decision, but required judges to do so on an individualized basis, taking into account not only the guidelines, but also various factors, including the age of the defendant, the circumstances of the defendant, the terrible nature of the crime, the harm to the victims. All of these factors are taken into account, and the probation office assists the court in determining what sentence is sufficient but not greater than necessary. And I appreciate, Senator, that you have looked at these from the standpoint of statistics, that you're questioning whether or not I take them seriously or I have some reason to handle them in either a different way than my peers or a different way than other cases. And I assure you that I do not. That if you were to look at the greater body of not only my more than 100 sentences, but also the sentences of other judges in my district and nationwide, you would see a very similar exercise of attempting to do what it is that judges do, attempting to take into account all of the relevant factors and do justice individually in each case.
Well, let's keep talking about this case. You also said to this individual who is an adult, tried as an adult, 18 years old, you also said to him, besides saying that you thought his victims were his peers, you also said there's no reason to think that you are a pedophile. And then you went on to say, again, that's another reason why you weren't going to give him, you're only going to give him 3 months because you would have judged that he wasn't a pedophile. And then you said, and this is something I really need your help understanding, then you apologized to him. And I just have to tell you, I can't quite figure this out. You said to him, this is a truly difficult situation. I appreciate that your family's in the audience. I feel so sorry for them and for you and for the anguish this has caused all of you. I feel terrible about the collateral consequences of this conviction. And then you go on to say, sex offenders are truly shunned in our society. I'm just trying to figure out, Judge, is he the victim here or the victims the victims? You're saying that you're apologizing to him. You're saying you're sorry for the anguish this has caused him. There was a victim impact statement in this case. It didn't get read into the record, but it was there. I've described the videos that we have. You say earlier in the case, you talk about how heinous these crimes are, and you describe them to your credit. You describe how heinous it is to your credit. And yet here you are giving him 3 months and apologizing to him and saying you feel sorry for the anguish it's caused him, and also saying you think that sex offenders are truly shunned in our society. So just talk about that. Help me understand. I mean, is he a victim? Is that your view here? Is that why you said this? Is that what you meant by it?
Senator, I again don't have the entire record. I remember in that particular case, I considered it to be unusual, in part for the reasons that I described. I remember in that case that defense counsel was arguing for probation, in part because he argued that here we had a very young man, just graduated from high school. He presented all of his diplomas and certificates and the things that he had done, and argued, consistent with what I was seeing in the record, that this particular defendant had gotten into this in a way that was, I thought, inconsistent with some of the other cases that I had seen. Part of what a judge is doing, as required by Congress, is thinking about this case, thinking about unwarranted sentencing disparities, that's in the statute, other cases, other determinations that a judge may have made about this. I don't remember in detail this particular case, but I do recall it being unusual. And so my only point to you is that judges are doing the work of assessing in each case a number of factors that are set forward by Congress, all against the backdrop of heinous criminal behavior. But the guidelines are no longer mandatory. Congress has not corrected, as you would say, the Supreme Court's determination about that. Justice Scalia's decision that the guidelines are not mandatory. Congress has not said that. And Congress has given judges factors to consider. This, in my view, was an unusual case that had a number of factors that the defendant was pointing out, that the government was pointing out, that the probation office was pointing out. And I sent this 18-year-old to 3 months in federal prison under circumstances that were presented in this case because I wanted him to understand that what he had done was harmful, that what he had done was unlawful, that what he had done violated the law and needed to be punished, not only by prison, but also by all of the other things that the law requires of a judge who is sentencing in this area.
But Judge, with all due respect, and I'm telling you what, I'll be direct with you. I am questioning your discretion and your judgment. That's exactly what I'm doing. I'm not questioning you as a person. I'm not questioning your excellence as a judge, frankly. But you said it. You had discretion, and that's exactly what I'm doing. I'm questioning how you used your discretion in these cases. And to me, to take a guy who's 18 years old, who has what the government says is an extremely large collection of prepubescent pornography, 8-year-olds, 10-year-olds, 11-year-olds. We're talking about, I mean, gobs of hours of time here that he has. And you say to him, what? That you say that, well, you know, it was just a collection. I mean, he was just viewing it, and it was, you know, essentially they were his peers. You say to him that he's not a pedophile. I don't know how you know that. I don't know why that's relevant to the guidelines, but maybe it is. You say he's not a pedophile. You say that you're very sorry for him and what he suffered, and then you give him 3 months when, frankly, a liberal prosecutor is asking for 2 full years. I mean, it does seem like an extraordinary case to me. It would bother me no matter what. It really bothers me when in every case, child porn case you've had discretion, you've sentenced below the guidelines and below the government's recommendation. And saying that sex offenders are truly shunned in our society, as you said to him, it reminds me, it echoes what you said as early as law school on that Harvard Law Review article Senator Blumenthal was just talking about. There you say, and I'm quoting you now, in the current climate of fear, hatred, and revenge associated with the release of convicted sex criminals, courts must be especially attentive to legislative enactments regarding these sex criminals. I guess like this, the enactment here, the Protect Act that Congress enacted. So I want to try to understand here, is it your view that society is too hard on sex offenders? You say they truly are shunned in society. You wrote that many of these laws are products of a climate of fear, hatred, and revenge. So just is that still your view? I mean, do you think that these laws are too tough, that we're too tough on sex offenders? Explain what you meant in this case in 2013, and it seems to be the same thing you said many years ago.
Senator, it's not the same thing I said many years ago. Many years ago, as a law school student, I was evaluating a new set of legislation, state laws about registration, and I was analyzing them as law students do. Wasn't about the sex crime, it was about the characterization of the law. Is it a punitive law? Is it a prescriptive law? And how would a court go about determining that? That was the frame that I used then. It could have been about anything. It was about the characterization of legislation.
But could just to, I'm sorry, I don't mean to interrupt you. I've only got 2.5 minutes left, but I just want to make sure I understand this. I'm quoting from your conclusion now. This is on page 1728 of the Harvard Law Review. This is your conclusion. In the current climate of fear, hatred, and revenge associated with the release of convicted sex criminals, courts need to be especially attentive to legislative enactments. So that's a conclusory statement. You're saying that there is a climate of fear, hatred, and revenge that are informing these laws. And you described some of the laws earlier, I think Megan's Law and others. Senator Cruz asked you about some of those. I'm trying to understand what you meant by that, because you're saying something similar in the Hawkins case. You're saying that society truly shuns our sex offenders. So
Senator, with all due respect, my article is now in the record. People can read it and they can see that I was evaluating these laws not to determine their constitutionality, not to say that they shouldn't be enacted, but to talk about the ways in which courts make determinations about the character of the law and all of the consequences that follow from them. In law school, I had not had any experience in terms of the criminal justice system, and I was doing what law students do. which is seeking to analyze in a creative way new legislation. With respect to Mr. Hawkins, I was doing what judges do, which is look at the statute 18 USC 3553A, exercise discretion as Congress has required us to do, take into account all of the various aspects of a particular case, and make a determination consistent with my authority, my judgment, and understanding fully the egregious nature of the crime. As you said, even the prosecutors in these cases are not recommending guideline sentences. The probation office, which is an independent authority looking at these cases and the facts related to them, are not recommending guideline sentences. This is a particular area where the commission has seen an enormous amount of disparity and has in fact asked Congress to come back and address, to help judges who are looking at these cases to be able to rely on the guidelines.
Which Congress has declined to do.
Senator, in that case, we have the statute that Congress has enacted concerning penalties, and we have judges who are doing their level best to make sure that people are held accountable as they need to be in our society in a fair and just way.
Mr. Chairman, my time's expired. Thank you, Judge. I have no further questions at this time.
Just checking with my staff. So the original statute was passed in 2003, the Scalia decision 2005, the Booker decision.
So the original statute that I'm talking about, I'm just thinking, I felt like it was in the 80s.
We think there may
In
have been
2003, I'm
2003.
all right.
And the
And then
decision by
Justice Scalia,
Scalia.
the Booker decision made the guidelines advisory so that even though judges have to calculate them, they are no longer binding. And what it meant in the statute is that the guidelines became one factor among many that judges consider at sentencing.
I'm not going to opine on Justice Scalia and his conduct and decision as it relates to the overall topic. I hope we all agree that we want to do everything in our power, reasonably within our power, to lessen the incidence of pornography and exploitation of children. You have made that clear. That is your position too. But I just want to tell you, Congress doesn't have clean hands in this conversation. We haven't touched this now for 15, 16, or 17 years. And you aren't the only one who faced this kind of a challenge with the cases before you. I said this morning, and it bears repeating, in United States versus Klotz, Trump appointed Judge Sarah Pitlick, Senator Hawley's choice for the Eastern District of Missouri, sentenced an individual convicted of possession of child pornography to only 60 months, well below the 135 to 168 month sentence recommended by the guidelines.
Mr. Chairman, you've mentioned
Let
this
me
now.
finish. I'll finish and then of course I'll recognize you. Senator Hawley, you've said some very powerful things in support of this judge, but clearly she faced a situation where she decided she would not follow the guidelines and took a sentence of less than half of what they recommended. We have created a situation because of our inattention and unwillingness to tackle an extremely controversial area in Congress and left it to the judges. And I think we have to accept some responsibility for that, Senator.
I just wanted to say, Chairman Durbin, since you mentioned Judge Pitlick in the Klotz case, she followed the prosecutor's recommendation in that case. As I've said over and over, part of my concern with Judge Jackson is that she has not followed the prosecutor's sentences. She didn't in the Hawkins case we were just talking about, or the guidelines. And I'm happy we can have a policy debate about whether or not the guidelines are too lenient. I would argue in this era of exploding child pornography, they're not too lenient at all. I think you were right the first time when you voted in 2003 to make them tougher.
I will just say that I don't know if you sponsored a bill to change this. I'll be looking for it. but I will tell you that there isn't a long line of people waiting to co-sponsor this controversial issue. If we're going to tackle it, we should, but we should concede in the meantime that we've left judges in the lurch in many of these situations. There is no clarity in this situation. And I think to hold this judge responsible for the overall situation is to ignore our nonfeasance, malfeasance, whatever it might be, and lack of responsibility in dealing with this. Senator Hirono.
Thank you, Mr. Chairman. Judge Jackson, as you may know, I ask the following two preliminary questions of every nominee who appears before any of the committees on which I sit. So I will ask you these two questions first. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
I have not.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
I have not.
Judge Jackson, my colleague from Missouri seems to think that it's appropriate for federal judges to sentence individuals below to sentence individuals below the sentencing guidelines in these kinds of cases, horrific cases. And so I think it's important to offer a couple of clarifications for the record. Judge Jackson, when the U.S. Sentencing Commission first addressed the issue of sentencing in this area in 2012, do you remember that only 40% of convicted offenders in this category were receiving sentences within the guidelines?
Senator, I don't remember exactly the number, but I do know that there was a great deal of variance from the
It's
guidelines.
40%.
Mm.
Would you be surprised to learn that the Department of Justice, which prosecutes these cases, sent a letter to the U.S. Sentencing Commission in 2013 stating that the existing sentencing guidelines for child pornography offenses do not accurately reflect the current landscape of child pornography offense conduct?
I don't remember that particular letter, but there was a lot of concern about this guideline from all sides.
And now the Sentencing Commission issued another report just last year on this topic. And do you know that as of that report, an even lower percentage of convicted offenders were receiving sentences within the guidelines? Did you know that?
I'm not
It was
surprised.
40%
I did-
before, now it's even less.
I didn't know, but I'm not surprised.
Did you know that as of last year, it was just 30% of non-production offenders who were sentenced within the guidelines?
I did not know, but I'm not surprised.
My Republican colleagues made a big show yesterday of promising a fair process. And to me, that means ensuring that you are treated no differently than any other federal judges that have nominees that have come before us. See, there was an article recently that highlighted the fact that many of President Trump's circuit court nominees who were previously district court judges had also issued below guideline sentencing to child pornography cases. Judge Ralph Erickson, who was confirmed to the Eighth Circuit in 2017 with support from every Republican member of this committee, who was serving in the Senate at the time, and there are at least 11 cases where he sentenced people to below guideline sentences. Does that surprise you?
It does not, Senator.
I'm not sure if you know Judge Erickson, but do you have any reason to believe he's soft on child pornography based on these sentences?
I don't have any reason to believe that.
Do you think my Republican colleagues are soft on child pornography just because they voted for Judge Erickson to become a federal appellate judge, even after he issued these 11 sentences?
Senator, I'm not in a position to evaluate whether your colleagues are soft on crime because of their votes. I have no reason to believe that.
They voted for this person, but I think it would probably be quite unfair to characterize him as being soft on child pornography. I would also like to talk to you about Judge Joseph Bianco. who was confirmed to the Second Circuit in 2019 with support from every Republican member of this committee who was serving in the Senate at the time, including Senator Hawley. In the case United States v. Bowen, Judge Bianco sentenced a defendant to 60 months in prison when his guidelines range was 151 to 188 months. And here's what Judge Bianco said in the sentencing transcript for that case, quote, "And the guidelines here are just way disproportionate under the facts of this case, and I don't view them as particularly helpful in this case. I believe the probation department got it right in terms of the statutory mandatory minimum being sufficient, but not greater than necessary to achieve the factors of sentencing." Quote, I'm not sure if you know Judge Bianco, but do you have any reason to believe that he's soft on child pornography based on that sentence or those comments?
I do not, Senator.
Do you think my Republican colleagues, including Senator Hawley, are soft on child pornography because they voted to confirm Judge Bianco to the Second Circuit even after he issued below guideline sentences and made these comments?
I have no reason to believe that.
Here are some of the other circuit judges that all of my Republican colleagues voted to confirm, despite the fact that they sentenced child pornography defendants to below guideline sentences. Judge Amal Thapar on the Sixth Circuit, Judge Richard Sullivan on the Second Circuit, Judge Andrew Brasher on the 11th Circuit. Again, I'm not sure if you've ever met these judges before, but do you have any reason to believe they don't take child pornography seriously?
I do not.
I would like to note that Senator Cruz referred to a chart that listed 8 cases and the government recommendations and the sentencing guidelines, and that you did not adhere to those sentencing guidelines. What was not included in the chart was what the probation recommendations were. And if you add those probation recommendations, in 5 of the 8 cases, you followed the probation recommendations. In one instance, you were lower, and one instance, you were higher than the probation recommendations. Mr. Chairman, I would like to introduce the complete chart for the record.
Without objection.
You've been asked to answer a lot of questions about your judicial philosophy. Some of my colleagues, particularly on the other side, seem dead set on finding out if you are an originalist, a textualist, if you believe in a living constitution, or various other labels. I don't find these labels particularly useful. Take originalism. Proponents claim you just have to dig deeply enough into the historical record and you'll somehow find the one true meaning of a constitutional provision. The fallacy of this approach is illustrated in District of Columbia versus Heller. There, Justice Scalia's majority opinion and Justice Stevenson's dissenting opinion each applied originalism. Justice Stevens more effectively, in my opinion, and reached completely different conclusions about the scope of the Second Amendment. Take textualism. In Bostock, Judge Gorsuch applied textualism to find that Title VII of the Civil Rights Act protected employees from discrimination based on sexual orientation and gender identity. In dissent, Justice Alito mocked Justice Gorsuch's application of textualism, and he wrote the following, Justice Alito, quote, "The court attempts to pass off its decision as the inevitable product of the textualist school of statutory interpretation, championed by our late colleague, Justice Scalia. But no one should be fooled. The court's opinion is like a pirate ship. It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated. The theory that courts should update old statutes so that they better reflect the current values of society," end quote. And these are 2 justices who are usually in agreement. So much for labels. So instead of trying to fix some label on you, I'd rather focus on the fact that you are fair and objective in your approach, that you are even handed in your application of law to the facts, and that you are independent. During your last confirmation hearing, you spoke about judicial independence, about what you learned during the 3 clerkships and your then 8 years on the bench. You said, and I quote, "I know very well what my obligations are, what my duties are, not to rule with partisan advantage in mind, not to tailor or craft my decisions in order to gain influence or anything of the sort." End quote. Well said. So my question is the following. What do you do to ensure that you maintain independence free of partisanship when you handle a case?
Thank you, Senator. What I do and what I've done in all of my 570 some odd opinions is to apply a methodology that is designed to ensure my impartiality and to respect the limits of my judicial role. What it means is that I am receiving the cases, and at the outset, I am setting aside any personal views that I might have about the parties, about the issues. As I also said in my DC Circuit confirmation, it doesn't matter to me whether the argument is being made by the President of the United States or a death row inmate. What I'm doing is looking at the argument, I'm looking at the facts, I am applying the law in as neutral and consistent a manner as I can, because that is the duty and requirement of the judicial oath. I'm also very conscious of the limits of judicial authority, of the restrictions that exist in the law to prevent me as a judge from becoming a policymaker. This means that I carefully scrutinize my jurisdiction. It means that I look at the text and focus on the text and the intentions of the legislatures that drafted that provision, or the intentions of the framers that put forward that constitutional principle. It means I'm looking at precedent. If I was fortunate enough to be confirmed to the Supreme Court, I would be upholding the principles of stare decisis as I consider the precedents and making sure that the court is putting forward consistent and predictable rulings, as is important to maintain the rule of law. All of these I see as constraints on judicial authority that I care deeply about in order to maintain my independence, as is necessary to ensure public confidence in my rulings as a judge.
Judge Jackson, I have sat on this committee now for a number of years. And as some of my colleagues continue to try to pin labels on the nominees who come before us, frankly, I find your methodology to be as succinct a definition of what would lead a judge to come up with fair and objective results. I thank you for that. As a lower court judge, you were generally bound by the Supreme Court's and the DC Circuit's precedents. That certainly won't be the case if you are confirmed to the Supreme Court. The Supreme Court can overturn its own precedents. That's why I found your analysis in Committee on the Judiciary versus McGahn instructive. In that case, you had a precedent, Committee on the Judiciary v. Myers, that had already confronted the issues you faced. However, it was another district court decision, and you were not bound by it. You nonetheless followed that precedent. Why did you find that opinion so persuasive?
Well, Senator, in the law, there are different kinds of precedent, and by that I mean There's vertical precedent, which is what people are most familiar with. There are cases that are handed down by higher courts, the appellate court, the Supreme Court, and those bind the lower courts so that even if you disagree with them, you have to follow them because they're binding precedent. But there's also horizontal precedent. It too is about maintaining consistency and predictability in the rule of law. And what that means is when you are in a district, there are many judges. And if someone else in your district has handled a case that comes out or that involves the same issues and comes out in a certain way, you as the second judge have to contend with that ruling. You can't ignore the fact that there is precedent in your district that handles a case in a particular way. And with respect to the McGahn case, the precedent wasn't just close, it was nearly identical. The Myers case involved the former White House counsel and the argument by the executive that the former White House counsel had absolute immunity with respect to a request by the legislature that she provide testimony. My case involved a former White House counsel who was claiming absolute immunity at the request of the executive in response to a legislative subpoena. In both cases, not only was the absolute immunity issue on the table, but in both cases, the same threshold issues about whether or not there was jurisdiction in the court because the legislature had standing or didn't have standing, which was the argument that was being made. The same question about whether the court could hear a dispute between the legislature and the executive branch. All of those issues had previously been considered by my colleague in the district court. And he wrote an extensive, I'm talking about Judge Bates, he wrote an extensive opinion analyzing each of the issues. And so at a minimum, as the second judge dealing with these exact same issues, I had to look at what he did and decide, was it persuasive? Did I agree? And I did.
Judge Jackson, of course, if there had been a vertical precedent, i.e. from the Supreme Court or the Circuit Court that was on point to your McGahn situation, yes, you would have had to follow that precedent, but there wasn't. And so you followed a reasoning by another district judge that made a lot of sense to me, and that certainly makes sense to me. You discussed stare decisis and the importance of precedent in your opinion, and this is what you wrote, quote, "It is interesting to note that the doctrine of stare decisis performs a limiting function that reflects the foundational principles that undergird the federal government's tripartite constitutional system. This is because deciding a legal issue anew each time that same question is presented without any reference to what has been done before nudges a court outside of its established domain of saying what the law is and into the realm of legislating what the law should be." I know that you've been asked the questions about the importance of precedent before, but maybe you can just tell us one more time why precedent is important in our judicial system.
Thank you, Senator. Our judicial system is one that is designed to uphold the rule of law. Unlike other systems in other societies, some other societies, we believe that we have a government of laws and not men. And yet there are men and women who are acting as judges in the context of our system. What precedent does is ensure that there's consistency across the different individuals who are tasked with the solemn responsibility of interpreting the law. It ensures that there's public confidence that the law is what is guiding judges in their decision making and not just their own individual views. And so it's crucial for maintaining public confidence, maintaining stability in the law, establishing a system that has predictability in it, all of which supports confidence in the judiciary, which is the currency of the judicial branch.
Because of the importance of precedents in promoting confidence, et cetera, people need to know what the law is. And so precedent is important on that score. And if you are confirmed to the Supreme Court, what factors would you consider before overturning precedent?
Well, there are many factors that the Supreme Court considers, and not just whether they think a prior precedent is wrong. That is one of the factors. The court has said that a precedent that is egregiously wrong is one that is subject to reconsideration. But in order to actually make the determination about overturning it, in addition to it being wrong, the court considers whether or not there's been reliance on that precedent, and if so, how much. The court considers whether or not the precedent is workable. Sometimes the court will issue a ruling in a case and it turns out that it's not actually functioning in the way that the court intended, and so that might be a reason to revisit it. The court considers whether or not other precedents in the area have shifted such that the foundation for the particular precedent is no longer sustainable. And the court considers whether there are changes in the facts that relate to that precedent, or a new understanding of the facts that relate to a precedent. All of those factors are things that that the Supreme Court takes into account when it decides whether or not to revisit a precedent.
Therefore, the court should consider all of those factors. I would say reliance factors loom large, as far as I'm concerned, before overturning a precedent. But basically, if you have 5 members of the court deciding to overturn a precedent, they can do so, right?
Under our scheme, yes, under the Constitution.
And so we're seeing more and more precedents being asked to be overturned. An analysis by National Affairs found that since 2017, when Justice Gorsuch was appointed to the court has shown, and I quote, an increasing readiness to overturn precedent, end quote. This is true for both longstanding precedents and those that are just a few years old. For example, in 2018, Janus decision, the court overturned a 41-year-old precedent called Abood. That decision weakened public sector unions. Justice Alito first signaled that he wanted conservative anti-union groups to challenge Abood in his 2012 decision in Knox versus SEIU. This is called signaling. And Justice Alito definitely signaled his desire to revisit the Abood decision. So yes, these groups, they got the message. They brought case after case to meet the criteria that Justice Alito laid out. And although they came close in 2016, Justice Scalia's death left the court stuck in a 4-4 decision in a case called Fredericks v. California Teachers Association. Basically, the minute Justice Gorsuch was confirmed, the court finally had a conservative 5-4 majority to overturn Abood, and the result was Janus. I followed these lines of cases very closely. So that is what happened. They waited for Justice Gorsuch and boom, 5-4 against unions. In another example, the courts acknowledged 4 most conservative justices, Thomas, Alito, Gorsuch, and Kavanaugh, dissented in June Medical, voting to overturn a precedent banning burdensome and unnecessary restrictions placed on abortion providers. This particular precedent was only 4 years old. Now the court is poised to overturn Roe v. Wade, even though women have relied on their constitutional right to have an abortion for nearly 50 years. Of course, I'm not suggesting that Supreme Court decision or precedents are sacrosanct, because I'm thankful the court can and did revisit precedents like Plessy v. Ferguson that were wrong the day they were decided. But justices should not be seen to be advancing their individual political or ideological agendas at the expense of individual rights and precedents that people have relied on. One result of the court's new approach is that people's view of the court is changing for the worst. A recent Pew poll found that 44% of Americans now disapprove of the Supreme Court. This is up 15 points from August 2020, shortly before the late Justice Ruth Bader Ginsburg died and Amy Coney Barrett was appointed to fill her seat. I think court watchers acknowledge there is an ideological split in this current Supreme Court, when we are seeing more cases decided on ideological bases, not on the facts and the law. I think it leads to the American people questioning whether the court is a fair and objective arbiter of cases in controversy. You were asked earlier today about your representation of Guantanamo detainees. Just to make it clear, as a federal public defender, you were assigned to represent Guantanamo detainees. Is that right?
That is correct, Senator.
And then while at Morrison and Forster, you also did pro bono work for Guantanamo detainees. Were you assigned to do that work as well?
So there was one detainee who I had represented as a federal public defender
Mhm.
who was brought into my firm's practice
Mm.
unbeknownst to me. And when I arrived at the firm, the attorneys who were working on that case recognized that I had previously been a lawyer who had represented this particular detainee and asked if I would help with his habeas petition at that stage.
I think you clarified that earlier today. And you served as counsel of record on amicus briefs related to detention. I think that was brought out today.
Yes.
Were you working on behalf of detainees at that point, or were you working on behalf of other groups or individuals?
I was working on behalf of other groups or individuals with
Were
respect.
they retired judges?
Yes, there were 3 briefs in total, 2 different cases, and one of the briefs that I filed was on behalf of 20 retired federal judges, including one who was a partner at my firm at the time, and who wanted to make a particular argument to the court concerning the detention process.
And these were judges that were nominated by various presidents, so it must have been a diverse group, and they asked you to do the brief.
And they did, yes.
So as part of your work at the law firm, a responsibility of your employment, you were assigned to work with this diverse group of retired judges and to represent conservative or libertarian organizations such as the Cato Institute and the Rutherford Institute to advocate their views.
Yes, the other 2 briefs that I filed were at the cert stage and then at the merit stage of a case that was eventually mooted. But my clients in those cases were a diverse group of organizations, including the Cato Institute, the Rutherford Institute, and the Constitution Project.
Members of this committee know full well that lawyers are, we have to follow the codes of professional conduct, which says that we have to zealously represent our clients, and that's what you are doing with regard to the detainees. And I would just want to note that some of the very senators who are openly questioning you for representing defendants or detainees have in the past made the argument that judicial nominees should not be opposed for the arguments they make in the course of representing clients. I'm going to quote one of my colleagues. I've been a military lawyer for almost 30 years. I represented people as a defense attorney in the military that were charged with some pretty horrific acts, and I gave them my all. The system of justice that we're so proud of in America requires the unpopular to have an adequate and an advocate. And every time a defense lawyer fights to make the government do their job, that defense lawyer has made us all safer. Do you agree with that?
I do, Senator.
In 2012, prominent conservative lawyers signed a letter defending attorneys who have represented Guantanamo detainees. In part, the letter said, quote, "The American tradition of zealous representation of unpopular clients is at least as old as John Adams's representation of the British soldiers charged in the Boston Massacre. Good defense counsel is key to ensuring that military commissions, federal juries, and federal judges have access to the best arguments and most rigorous factual presentation before making crucial decisions that affect both national security and paramount liberty interests," end quote. So the quote that I read isn't the first time that my colleagues on the other side of the aisle have tried to say that your representation and your work as a public defender somehow, I don't know, disqualifies you or makes you leaning one way or the other. So you've made it very clear that that is not what you are about. I just have one more question in the remaining time. Oh, I'm sorry. I'm over.
Senator, I'm sorry, we're on a roll call.
I'm on such a roll.
You're on a roll and we're on a roll call.
Yes, thank you. I
Mr.
apologize.
Chairman. Mr. Chairman, before we break, if I could ask one question of the chairman.
Sure.
Senator Hirono just made reference to the recommendations of the probation office in 5 of these cases. To the best of my knowledge, those probation recommendations are not in the record. I haven't seen them. My staff hasn't seen them. And that raises 2 questions. Number one, whether the White House is providing differential material on this nominee's background to Democratic members than Republican members, because I don't know where Senator Hirono would get access to them other than from the White House. But secondly, regardless of whether it's differential, would the chairman agree that there is considerable focus on these cases and the committee, both sides, should have access to the pre-sentence reports and to see the underlying facts? Judge Jackson has said she was following the facts and the factors in those cases.
Senator, you know we've completed discovery before we started this hearing.
Mr. Chairman, how
For
did
you to
Senator
have a-
Hirono, how
I'm
did
not
Senator
gonna-
Hirono get those information that
I'm not gonna-
Republicans have not been
I'm
given?
not going to entertain this. We've been through discovery.
Do you have access to them?
I don't know that I do. I really don't.
Can we ask Senator Hirono how she got access to them?
I'm sorry to interrupt you, Senator, but I want to make an announcement. We're going to have a 10-minute break. Members are going to head to
So
the
you're going
floor.
to keep differential access to this information?
I'm not sure what differential access is. I'll look it up. We have a vote on the floor that take about 10 minutes. So 10 to 15 minutes, relax. And then we're going to come back and we have 2 senators, Cotton and Booker, who will be recognized and then take a break for dinner. And then we're going to try to still finish tonight with 2 remaining senators, Senator Ossoff and Tillis, who are going to be first thing in the morning. So we stand in recess.
There, we've been watching the Senate hearings on whether to confirm Judge Ketanji Brown Jackson as Associate Justice on the Supreme Court. The committee is now taking a short break. Watching the hearing along with me is John Yang. He covers the Supreme Court for us here at the PBS NewsHour. John, we heard Chair.
All right, so ladies and gentlemen, thank you all for staying tuned this long. We will definitely be following the story. So make sure you guys are liking, subscribing, and sharing. Thank you all for coming out today. And until next time, we'll see you next time.